5 seconds. The appellant and respondent were duly married on 26th April 2007. Unfortunately, after a couple of years, differences started between them, which culminated in a decree of divorce granted by the Family Court, Ghaziabad, on 20th September 2014 in case number 765 of 2011 on the ground of cruelty. The matter was pursued before the High Court of Allahabad, leading to the impugned judgment dated 9 September 2015. The High Court confirmed the decree of divorce. However, regarding the permanent alimony, despite the compromise said to have been entered between the parties for a total amount of rupees 36 lakhs, the High Court reduced the amount to rupees 29 lakhs. It is not in dispute that an amount of rupees 31 lakhs had already been paid by the respondent before the High Court. Learned counsel appearing for the respondent husband submits that pursuant to the order passed by the High Court, a further amount of rupees 5 lakhs has also been deposited with the Family Court, Ghaziabad. When the matter came up before this court on 4 September 2016, having regard to the submissions made by the counsel for both sides that the parties would like to have a peaceful settlement of the entire disputes, they were directed to appear before this court in person. Accordingly, the appellant Miss Priyanka Chawla, accompanied by her father Mr. Girish Arya and respondent Mr. Amit Chawla, are present before the court. It is agreed that in addition to the amount of rupees 21 lakhs paid by the respondent husband, a further amount of rupees 5 lakhs will be paid within a period of 6 months. It is also agreed between the parties that the decree of divorce granted by the Family Court, Ghaziabad, on 20th September 2014 be set aside and the parties be granted divorce by mutual concession on a point petition that is filed by the parties before this court. It is also agreed that all other civil and criminal litigations between the parties as of now pending in various courts be also put an end to and stand quashed. Having regard to the fact that a decree for divorce had already been granted as early as on 20 September 2014, in the interest of justice and for doing complete justice, the cooling period is waived and the parties are granted a decree of divorce by mutual consent. The appellant is permitted to withdraw the demand draft of rupees 5 lakhs deposited by the respondent before the Family Court, Ghaziabad. The respondent will pay the remaining amount of rupees 5 lakhs by way of demand draft drawn in the name of Miss Priyanka, appellant, on or before 30th June 2016. The court appreciates the sincere efforts made by the learned counsel for the parties for an amicable settlement between the parties and also the cooperation rendered by the parties. This appeal challenges the judgment and order dated 21st December 2013 passed by the High Court of Punjab and Haryana in Criminal Appeal number S1793 of 2011, confirming the conviction and sentence of the appellant and one Jaswant under sections 398 and 401 of the Indian Penal Code and section 25 of the Arms Act. On 18 December 2014, this court was pleased to issue notice limited to the question of sentence. According to the prosecution, the police had received specific information that the appellant and one Jaswant were planning to loot passing vehicles near Amar Gas Agency store situated in sector 21D, Faridabad. This information was received on 9 February 2009 after 9:30 p.m. PW2 Ishwar Singh, ASI, was already present in sector 21D, Faridabad on patrol duty. On receipt of the information, he along with raiding party proceeded towards the spot. According to PW2 Ishwar Singh and PW4 Head Constable Yasin Khan, they saw a white colored Indigo car parked at a deserted spot. They further saw that the appellant and said Jaswant tried to stop a passing Maruti car, but the driver evaded them and sped away. The police overpowered the appellant and said Jaswant, and on their personal search recovered a knife from the appellant and an iron rod from Jaswant. On search of the car, the police found 2 number plates, one having car registration number of Madhya Pradesh. The photographer was called and photographs of the vehicle and the site in question were taken. During investigation, it was discovered that said car was actually owned by LIC and was a stolen vehicle. Neither the appellant nor said Jaswant could come up with any explanation how that car was found in their possession. Further, both these persons were steadily residents of district Gonda, UP, and not residents of Faridabad. The trial court, after considering the material on record, found that the case as against the appellant and Jaswant was fully made out. It convicted both the accused under section 398 IPC and sentenced them to suffer rigorous imprisonment for 7 years. They were further convicted under sections 471 IPC and 411 IPC and sentenced to suffer rigorous imprisonment for 7 years and 1 year respectively, with imposition of fine and sentences in default.
Subscribe now and press the bell icon. Never miss an update.